Good morning or afternoon to everyone. Thank you for joining us today. We have a very special presentation and panel. Titans of the industry, as I'll call it for today. We're going to have some fun. This is asset sales and receivership, and this is episode number 3 of the Financial Poise State Court Receivership series. You can read more about Financial Poise on slide 40. Today, our panelists are Alan Guan from Cozen O'Connor. We have Eric Morcheski from NMBL Strategies, as well as Frank Simon from Simon PLC. My name is Matthew Brash of New Point Advisors Corporation, and I will be your moderator today. You can see our names on slide 5 of the presentation, and you can read our bios on slides 32 through 35. Neither Financial Poise nor we intend for this to be an infomercial, so you don't have to listen to me read our bios. Feel free to review our bios on the slides or go to our websites or click the links. If you want information about us, like I said, just go ahead and look at slides 32 to 35 or click. About the slides, I'll try to call your attention to slides relevant to what we're discussing, so you can take notes if you like, but don't worry if you're listening but not watching this webinar. You'll be just fine because the slides are not critical. This is more of an open forum, open discussion regarding asset sales in receivership. I would also like to take a moment to thank our co-producers, the National Law Review, as well as Daily DAC. I'd also like to thank our sponsor, Max Asset. You can read more about our co-producers and co-sponsors on slides 36 through 40, through slides 36 through 40. The last thing before we begin is slide 4 contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for general education and discussion purposes and not for you to act on without appropriate advice. As I discussed, today we are doing asset sales and receivership as series number 3 in our webinar. We'll be concluding our webinar series next week on May 28th with how to conclude a receivership. And without further ado, we're going to get kicked off here. Eric, general discussion of asset sales and receivership. What is an asset sale and receivership? Give a general overview and description, please.
So I look at a receivership as obviously it's a court engagement that the judge is taking control of the entity or the property that's being put into receivership. And typically, I would say there are 3 outcomes that come out of it. And as a receiver, you should hopefully have a general idea of which direction it's taking when you're getting in, because you also anything you get into, you want to know how to get out of. So those 3 groups I would consider a liquidation or an asset sale that can either be whole or parts of the entity. So it may be part of it so that the restructuring can take place and you can return back to an operating entity. You can sell it as a going concern, or in certain cases, there are settlements that are being made as a part of the receivership. And so there isn't really necessarily a transition through a liquidation or a going concern. So today we're really talking about the asset sale or the liquidation piece. Asset sales typically take place, like I said, either in whole or in part of the entity. Sometimes we are just looking for what is of value so that we can return an entity to operation with a better cash flow model or a better opportunity. Sometimes we are looking at just liquidating the whole thing and selling it all off. Frank, Allen, I feel free to chime in here too. I don't know if you've had experience in any of those, anything beyond those kind of 3 primary models of liquidation, going concern, or settlement. But I would say, in my experience, at least, most liquidations that you go through are for the whole entity in a receivership. There are exceptions to every rule, but most of them, when we get into a receivership, if we're going through a liquidation, it's likely because the going concern is not salvageable. So there's probably not even enough money to keep operating tomorrow. But add on to that, the liquidation value is likely higher than the going concern value at the time. And ultimately, the liquidation value in a receivership is probably going to be lower than if it was being sold off piece by piece as part of a going concern. But I heard someone say this earlier today, so I won't take complete credit for it, but your liquidation value is your minimum floor as you return cash to creditors. And I think that was a really well put statement that they made earlier today, with thinking through a receivership. If you are going through a sales process of any sort, where is your floor at, in that liquidation through a receivership sale, through an asset sale is really your minimum floor to everything that you do moving forward.
I think that's excellent. Well said, Eric. And I agree with you about the liquidation, although it could be more than the going concern value, perhaps because you're running out of cash. You don't have the ability to sell in a going concern. Liquidation is, really it is the minimum, it is the floor. Frank, how often are you seeing asset sales as a driving force for petitioning a court, for a receivership? You're both an attorney, you're also a receiver, so you're able to see kind of both sides. Generally, like, what are you seeing when you're contacted or when you're petitioning a court for receivership? Is the main focus that we're going to get the assets, we're trying to sell, we're trying to monetize this, and that is our number one priority.
Yeah, well, a good question. I think it all depends on the type of receivership and the type of assets that we are talking about. So, some examples are I was just recently appointed receiver over a title agency that involves a well-known large underwriter, and this title agency that was a partner with this underwriter had a high volume of closings. They were pretty busy outfit. So I think in this particular case of the title agency receivership that I just recently got appointed a couple of weeks ago, there really is nothing to sell. Um, and so the appointment of receiver was not made for the purpose of selling any type of assets. There are really no assets. Our objectives here and tasks is really to do some auditing, forensic accounting, as well as some auditing and review of all sorts of documents, closing statements, and so forth, and going through the software, going through emails to see what transpired here. There were some allegations of fraud, allegations of embezzlement, allegations of closings not done properly, that things were missing at the closing uh, table. And so there's all sorts of things that went wrong with this agency that we're trying to get our hands on and figure out really how much is at risk for this underwriter. We know there's several million at risk, and it could be a lot more. Um, so, back to your question of, the driving force for petitioning a receivership. I think it all depends on the type of receivership and the type of assets that it involves. On the flip side, got appointed receiver over a large apartment complex, and with that particular one, the big driving force was selling this big complex.
Absolutely. Alan, kind of piggybacking off of that, are you represent a lot of receivers. You also are a counsel and uh, one of the writers of our Illinois Receivership Act here. So we're lucky to have you here. How common are asset sales in a receivership? Like I said, you represent receivers. You're also an attorney. You've seen both the plaintiff defendant sides. What has your findings been from your experience?
In the cases that we're involved in, it's almost always the case that assets are sold. Not 100% of the time. I mean, receiverships, are designed initially. They go back to the 1600s, 16th century, and they're kind of designed for a court to hold assets in custodial legis, possession of the court while a proceeding is going on, a legal proceeding is going on, and then return to the owner. But it's obviously developed. There's a lot of established case law in the United States that it's a very effective forum to liquidate assets. And secured creditors, regulatory agencies are often using the receivership proceeding to take control over an entity and liquidate the assets to recover for creditors or to provide restitution. So of some sort to defrauded, consumers or individuals. But it is almost always, in my experience, a mechanism used to liquidate and sell assets. If the assets are already liquidated, sometimes it's just a pile of cash. then you're just using the receivership to distribute money or stop, bad actions from happening. But most of the time, because of how quickly you can secured creditor can get control over the assets, it's generally used by the secured creditor or judgment creditor to liquidate assets of the entity.
Excellent. I agree. So in order to do an asset sale, we need to make sure that we have possession and security of those assets. I know that in getting appointed as a receiver, those first day action items, and the thing that keeps me up at night is making sure, we have full control of possession, understanding of all the assets, where they are, make sure they don't go legs and walk out the door. Eric and Frank, what are effective initial steps for a receiver to promptly secure control over physical or operational assets upon appointment? What steps do you guys take?
Yeah,
know-
so I'm sorry, go ahead.
Go for it, Frank.
Oh, okay. I would say the first initial step with a new receivership is the receivership order. I think the order is the gospel of any receivership, and it needs to spell out all the details as much as possible with all the issues that are and the objectives and the receivership, particularly the immunity for the receiver and their agents and professionals, along with the power of sale. If this particular receivership entails a sale of assets, some receivership orders don't even have a power of sale, so that's a big item to make sure to have included in the order, along with reporting to court and how often one needs to report to court, and how often do you need to get approval on certain things, whether it's a sale or hiring up professionals. So I think that the first step is always the receiver order and trying to get the receiver order in line with the objectives.
Eric, any follow-up to it?
Yeah, I think once your receivership order is in place, and Frank's exactly right. Obviously, you can't, you can't run before you walk. But once you are out there running, because day one of that receivership, once it's in order and your bond is placed and everything, you are running. Make no mistake about it. And so, I think I look at, when I'm looking at securing assets, I'm looking at operating versus a non-operating company, right? Because in many cases, it's a lot easier to secure the assets of a non-operating entity. If you're operating and you've got, a CFO that's still there, if you've got, payroll that's going on regularly, you may not, as the receiver, want to be handling every minute detail, but at the same time, you've got to secure assets like the bank account. And so you have to have a little bit of an assessment of the personnel involved. And that really starts, from my perspective, with the debtor's position to the receivership. Because if they're very adversarial to the receivership, if they are very aggressive towards you as the receiver, you probably have to take a much stronger approach to an operating entity or a non-operating entity than you will for, a debtor that is either, co-signed on your appointment in the receivership, or, is really being there trying to be helpful because they realize that, one, you as the receiver did not create the issue, and two, you're not playing favorites to anyone. The only person you're a favorite of as the receiver is the judge, right? That's the only person that you are on their side 100%. You are there to support the creditors, obviously, and that's your role, and that's the judge's role, but you are representing the judge, and you need to make sure that when you're taking those actions, that you are representing them in an appropriate way, which really, to Frank's point, follows that receivership order.
No, I agree.
And I think,
Go ahead,
sorry,
Alan. No, Alan, please go ahead.
often that initial assessment is key because the fiduciary, a receiver's a fiduciary and responsible for everything that happens. And if it happens, something bad happens on the receiver's watch, that's going to be their problem. And so as a fiduciary, if as Eric said, it's a contested process, then you have to think about, do you want to change the locks? Do you want to change all the passwords to the computer systems? Do you want to get a backup of all the email to make sure nothing's been deleted because there's going to be litigation? How do you secure that? Do you want a static copy of all the records? You may want to take an inventory right away. You may want to get an appraisal to find out what the value of those things are. I had one case where the owner was trying to steal checks. We had to immediately change the lockbox, and change the mailing address. We had to run to court to get a check back on a contempt hearing. And then there were issues in that same case, issues with an electronic payment system where vendors were using this payment system and the owner was trying to divert payments. So we needed to change those passwords as well. So, as Eric said, depending upon how controversial the appointment is and how contested it is, security can be a big issue, and you gotta assess that really quickly to make sure you get control over the assets and can't let them let the insiders try to pilfer them away.
Frank,
One thing I want to add to that, if I may, quickly here, is that back to this title agency that we just took over. Upon our appointment, we immediately brought in an IT company, an IT specialist, to immediately secure, like you said, Alan, secure all the emails, secure all the databases, remove passwords, change passwords, and so we got everything on a thumb drive, but immediately had everything forwarded to us. So all the emails that are flying is actually coming to our office, still is today. We're seeing all sorts of things. But yeah, I mean, an immediate security on the IT was critical in this particular case. Sure.
Yeah. I mean, and all three of you had excellent points there. And, Alan talking about, we went into the preservation and, specific security measures, which you just discussed, which is incredibly important and critical. I feel like every receivership I get appointed to, they're all adversarial in some form, unless you have some type of agreed order between a partnership dispute or some other type of nature. But I can pretty much guarantee that 99 out of 100 times whenever I'm appointed, it is, you're off and running and racing to make sure that you're controlling everything, because there are several occasions where they're trying to pull funds out of the account or move assets or inventory, just make your life really difficult. So it's going to be critical. And I agree with you, Alan, about that as well. And taking those security measures and taking those first steps to change passcodes and put things in place to do your best. And I always tell my team, when you leave that business or that collateral or asset each day, have you been able to properly document that you've done everything humanly possible to preserve and secure that collateral? Because like you said, Alan, it comes back to the receiver. The receiver is the one in charge. And, in those first few days, things can move and happen and you really have control over that, but you do the best that you can.
Right. And also I should say, the other thing I forgot to mention is
Go ahead.
make sure you have the insurance.
Yes.
You need to be the additional insured. You need to make sure there's valid insurance there, because if there's a loss and there's no insurance, you got a big problem as a receiver. So you got to procure the insurance to the extent that's not there to protect any inventory, to protect the building. So that's the other thing you really need to make sure. So you still have an asset to sell if there's an accident.
Well, let's talk about that. Let's talk about that while you mentioned insurance. So, Eric, what insurance coverage should receiver secure immediately upon appointment to mitigate loss? And what unique insurance considerations arise when dealing with specialized or high risk assets?
I think really most receivers like to start with D&O, right? And I think even amongst the receivership groups that you and I are both a part of, I think there's even some debate of whether a receiver qualifies for an in-place D&O policy, because they aren't really a director and officer of the company that was put into receivership when the policy was written. You're acting on behalf of the courts, and so really, I think the first thing that you really need to look at is, from my perspective at least, was the policy changed recently? So I like to look at, for 20 years we had a policy in place, and last year you changed it, and now we're covering, you know, a lower limit threshold because cash was tight, and so we cut costs by, you know, that's where, to Alan's point, if something walks out the door or a fire starts or whatever it might be, you know, you're not properly insured. So I think limits become a big thing when I'm looking at them, just to make sure that you have proper limits in place. And sometimes that's a hard assessment, right? Because you have to start with the inventory of the assets to even know what value is even there. And a lot of times you probably need proper appraisals done, because you can look at a machine that sells new for $10,000 and it's 2 years old and it's worth $1,000, but it hasn't been handled right and it's worth $100. And so, you know, there's all these factors that go into it. And more than likely, when you're coming in as a receivership, probably hasn't been handled right. So it probably is the $100 value because they couldn't afford proper maintenance on it. And that was an easier cut to make than a staff member. So I realize I veered off a little bit on the insurance coverage. But I do know, you know, we all like to start at D&O. I also like to start at our own corporate coverage, you know, from a receiver standpoint, making sure that we have proper professional liability in place. Fortunately, I've never had to find out how valuable that is, but you really, you know, you got to start with protecting yourself, and protecting yourself from day one when you walked in happens because you protected yourself before you got appointed. Once you're appointed, then obviously you're starting to look at the corporate policies, and that really varies a lot within the industry that you're in. If you are talking a manufacturing plant, it's very different than the title insurance that Frank mentioned, or, you know, any number of companies, you know, a hotel operation or anything else that you might be seeing in place. And so, you know, the other thing I guess I would say along the insurance coverage is talking to a broker that you trust, and making sure that the policies are in place and that the company that it's through is a legitimate entity and not, you know, some lower tier, cheaper insurance policy that's in place that really probably won't be covered, or making sure that really you're covering all your bases, just not just with what the policy is, but also who it's from and what it's insuring.
Sure. I want to move forward to the sale process. Frank, what initial steps should a receiver take to accurately assess the market value, marketability of assets at the beginning of a receivership?
Yeah, so I would say if it involves real estate, we always get a broker's opinion to give us an opinion of value. And then also, we also get an appraisal on the properties and get a better understanding of how much these properties are worth. If it involves equipment or machinery, we do the same and get a company that specializes in particular machinery. You know, we had a receivership where it was involving farm tractors and farm equipment, all sorts of things from that side. So we actually had to hire someone who has expertise in the farming world, and that's all they do, and gave us some great information on what each piece of equipment was worth. There was a lot of equipment on this big, large farm, and so we ended up actually doing well, selling, you know, about 50 pieces of equipment, and it turned out to be actually a very good recovery, selling all those pieces of equipment. So we definitely have to hire the right expertise with regards to either the real estate values or equipment. And usually we get people in that field and local people who know the market.
I want to go to Eric, then Alan. Can you describe the typical phases of an asset sale in a state court from initial planning to closing?
From my experience, it really starts with an appraisal, because again, you have to know the value of the assets that are involved. So from an appraisal, you're veering one of two ways, right? You're going straight to a liquidation, or you're trying to sell it more as a going concern, as a package of assets. If you are going the going concern or a package of assets, we start with a marketing package, and building a depth of the market. So who are the players in the market? And those typically involve two phases, two groups. Sometimes there's a third group. We have one right now that has a third group in it. So they're active players within the market. So if you're manufacturing signage, then other signage manufacturers. If you are also, then you need to look at the other group being location based. So a lot of cities, they really support their own local vendors, local manufacturers, and so they will really get behind the idea of buying it and keeping that company in their market. The third one we found in one of our recent ones is fans of the company, and that one's been a little unique, I think more specific to this particular company than anything else. The next step really is proactive outreach. So talking to all those people with the marketing package, saying, here's what it is, here's what's in there. Typically, we're building a data room, we're giving tours of the facility. Then you really get into what the sales process is, whether you're going to go to a stalking horse bidder, someone that's going to set the floor for you with the quotes that you are going to take into the judge and say, I have an offer of $5 million. And if it's going to allow us to offer other bidders in the next 45 days to bid more than that. And in turn, we'll come back in and we may have to pay them something for being our first in offer. The other avenue that's especially typical in real estate is really more similar to how we sell our houses, right? It's we put it on the market and we hope to God someone shows up and says, I'll give you close to that. But that path is not atypical depending on what your asset is, and understanding your assets becomes critical, and that's where that appraisal from the start really helps feed that information to you. And the third that we've used sometimes is just going straight to an auction that we know we have an asset that's such value to it that there will be a market for it. We don't want to spend 2-3% of the asset value that could be returned to creditors on a stalking horse bidder. That one's probably used a little less, and you really have to have a lot of confidence, because if you go to an auction date of submitting your bid by X date, you better pray to God that there's at least one bidder that's put in that bid at that date, if not more. Then all of this is going through with court approvals, right? Because as the receiver, I think Frank or Alan mentioned earlier, you're selling it only if you have the rights to sell it in your receivership order. And typically, even with that right to sell, you still want to make sure the judge is on board with your process.
Agree. Alan, any thoughts on that? And also kind of want to hear your opinion about determining the most appropriate sale method. We talked about the various aspects and various avenues you can go down. I'd like to get your feedback on what Eric said and add to any of that, as well as the question of the type of platform to sell.
Well, I mean, what Eric said is exactly right. It starts with an evaluation of the asset. What is it? Sometimes you have to hire a professional to help you because it's a strange asset that you're not familiar with, or it could be in the receiver's wheelhouse and that receiver knows exactly how to market it. But it's a case-by-case decision. You have to look at, is there a recognized market for this type of asset? Is it a stock? You could just go out in the marketplace. Is it a food product that's, like fish, where you're just trying to sell the entire lot of fish? You know what the price is per pound because it's marketed. There's a market for that. Is it time sensitive? Do you have a melting ice cube? You got to do it quick. As Eric said, if it's a piece of real estate, that you're selling, you have a developer that sells a whole bunch of lots, you're not gonna, you may do an auction for a whole bunch, or if you have a completed home, maybe you market it to an individual and you just do a private sale to the individual, because most individuals won't do, a whole auction for buying a home, right? They're just gonna want to buy it and move in. So it all depends. But as far as doing like a bulk sale or selling in lots, sometimes we do it all the different ways. Sometimes if we want to try to sell it, for example, as an ongoing business, we will take bids to buy everything. We may say, okay, alternatively, let's have bids for just the assets, particular assets, or bids for just the litigation claims. And we'll see, maybe the liquidation assets plus the litigation claims total more than the going concern value. And so we will do 2 separate lots, but we'll take bids for all of them, and the receiver will make a decision as to the highest and best offer, and then go back to the court and explain his or her decision on why they're, unfortunately, they have to close the business and terminate these jobs because there's so much more value in just the liquidation and sale of specific assets. So
Excellent.
it all depends on the specifics of the case, but but usually, you try as many different avenues as possible.
I completely agree.
Value.
Frank, what specific steps or practices help ensure transparency and fairness in the sale process, especially like in giving notice to parties or to the marketplace?
Yep. Good question. I like to give examples from my current receivership cases we have going on, and we have one now. It's a family law matter, a very nasty divorce, big divorce, and there's been lots of fighting over all these assets, particularly jewelry, and other types of personal assets that the couple owned at one time. And so we actually did a private auction in our office, and we outlined the rules from the start. So we provide all the parties the rules on how they bid, how much they could bid, the time slots, what time the bidding starts, what time it ends, the days of the bidding, so everyone knows the rules from day one, and they start bidding. And what we do is it's all transparent, where it's all in an email to all the parties, giving them the chance to bid more if they want. And we let them know what the bid amount is, so forth. And that's kind of how we did it on this particular case. We had another case involving a sale of a hotel where we did a similar thing. We had everybody in our office, and they all did a blind bidding where no one really knew the price. We end up giving everybody the rules in advance. We told them that by the end of this day, we're going to pick the highest bidder. And that's how it happened in that particular case. So I think it's kind of one of those things where you have to set the rules in advance and let everybody know the rules. And once they know the rules, it's more of a private sale, private auction is how we do it.
I completely agree. And it's so key because I know that with giving notice and making sure that all the rules, as you said, rightfully, Frank, are stated very clear and or approved by the court and given proper notice and timing. Like that way no one can come back to you and say you didn't take any commercially reasonable efforts to do or, facilitate whatever asset sale that you're doing. So I completely agree. Let's talk about the availability of free and clear sales orders. Alan, what does free and clear mean? Why do we need court authority on it? I know as, again, one of the writers of our Illinois Receivership Act, part of that is getting to the point where it's almost just, it's common and it's kind of law that receivers can do asset sales without having to run back to court and go through all the motion practices and everything. Kind of dive into free and clear for us, if you don't mind.
Sure. Well, a free and clear order is generally necessary in order to transfer assets free and clear of liens, claims, and encumbrances. Sometimes that may include successor liability. So if you want to maximize the value of an asset being sold outside the ordinary course of business, right? You're liquidating a company. We can talk about ordinary versus outside the ordinary course, but you generally need a free and clear order to sell free and clear of liens, claims, and encumbrances when you're selling outside the ordinary course of business. And you're going to have to get court approval to do that. You need that order because A, it maximizes value. No buyer's going to buy anything from a receiver, almost never, without it being free and clear of all the nastiness that brought the case into the receivership. And also you're going to need a free and clear order if you want to have any value for your real estate, because A title company, you need title insurance to sell real estate. I mean, everyone understands that. But if you don't have a free and clear order that the title company believes is appropriate, you're not going to get title insurance. You're not going to be able to sell the property. So you need an order that a title company, as we used to call them, the Supreme Court of LaSalle Street, because that's where they used to be. If you don't get their sign off on the order and it doesn't make them happy, you're not going to be able to insure the real estate. So free and clear orders are generally essential to sell outside the ordinary course of business. Most receivership orders allow a receiver to sell in the ordinary course of business without a further court order. And that is basically ordinary course of business is the normal routine business of the company. It's routine and expected. Outside is anything non-routine, major asset sales, liquidation, going out of business sales. So like similar to the Uniform Commercial Code, a buyer can buy free and clear of liens if you're selling, a shirt, a clothing retailer selling clothes in its ordinary business. It's not subject to the lien of the secured creditor. So if it's something that is just sold in the business, you're renting units as part of a rental building, residential rental building, that's the ordinary course of business. But if you're selling the building itself, that's outside the ordinary course of business, and you're going to need an order to do that.
Can you, Alan, talk about the state of Illinois, basically what you see from free and clear, and it's what's the current statute and what we're shooting for the state of Illinois from a receivership standpoint?
Yeah, Illinois receivership law is in need of a dramatic overhaul. And as part of that, we put together a group. You've been helpful with that, Matt, that drafted a statute to enable courts, parties to use the receivership process effectively in Illinois. In Illinois, it's only common law. The statute is like 4 sentences long. There's no real great common law that fills all the gaps. And it's different wherever you go. Some courts understand receivership, some don't. So we tried to develop a statute that provides some guardrails. Some courts in Illinois will not allow a free and clear sale. So because there isn't a lot of authority out there. And so receiverships are not a very effective remedy now. Hopefully, the statute will be passed later this year that will provide some very clear legislative guidance on what receivers and courts can and can't do in receiverships. So it should help really provide a very good process for parties to have receiverships in Illinois, which is not currently available, and it's not really an effective remedy. So hopefully, keeping our fingers crossed, in the next 2 months, we'll have a statute.
Well, your number one fan and backing of that is right here on this webinar. So, Eric, talk to me about the state of Missouri.
So similar to Illinois, we were based on case law coming into 2016 when we adopted new statutes. So we were in Missouri really the third state that started updating statutes away from case law. So starting with the state of Washington in about 2002-ish, and then Minnesota in 2012, Missouri then followed in 2016. Really starting to look at receivership should be a better, more useful process within our states that's not based on case law, because that was creating an issue that banks didn't like a lot of times, which is there's no certainty to what's about to happen. And so free and clear being a critical component of that. When we adopted our statutes in 2016, which was the same year that UCRERA was passed, and that a lot of other states have since adopted, which is starting to make this a much more available national practice from the free and clear aspect. We do bring free and clear into the court system. We do expect it. We are still seeing some issues with title. So even though we do have it free and clear in our order, in our statutes, title companies are still a little hesitant because it's not really been challenged. It's not really been appealed in a receivership case yet. And so, they're really coming in saying, we're going to let the appeal rights expire before we want to write title on this. And so when you're trying to move quickly, that can be one of those hiccups that comes in along the way. It's still a great aspect to have of it that you have this free and clear, but you're also going to have to explain to a potential buyer who maybe is coming in from out of state why free and clear means free and clear in 30 or 45 days, not free and clear tomorrow.
Excellent.
Right. Eric, we try to put that in our statute that like 363M, a bankruptcy sale where you can close as long as there's not a stay. But you're right, it's gonna, as I said before, it's gonna depend on what the title company wants. And I always run my proposed orders to a title company before the process starts if I can, because it makes the whole process of getting approval that much quicker.
Frank, how about in Michigan?
Yeah, so Michigan has a great statute. It was implemented many years ago, and it's definitely a free and clear sale state. And the majority really of the receiverships that happen in Michigan are involving the sale of assets. And so, yeah, it's a great statute that we have. And all the judges that appoint receivers are familiar with this and are all favorable of free and clear sales. So we've never had an issue.
Excellent. Eric, engaging professionals is key in maximizing asset sales and having the right team in place. What criteria do receivers consider when selecting that team? Brokers, auctioneers, appraisers, investment bankers, other type of sales professionals to represent the receiver and the estate.
So, and maybe I'm a little unique in how I think of this, maybe not.
You're
I
unique. That's why we love you.
But I really, you really should start from, will they bring more value than they cost? Because if they're not going to bring more value than their cost, why are you doing that when that money is coming away from the creditors? Assuming that there is no other option, let's say we're just going through a liquidation, then it's multiple bids is a good starting place because you can justify to the courts why you hired one company versus another and that it wasn't your cousin, that you were hiring as a part of the process. And then, certain industries are going to require industry knowledge and expertise. So if you are liquidating and you're selling real estate, obviously you're going to want someone specific to the location, someone specific to the industry, depending on what type of real estate it is. If you're looking through an auction process, you may want to make sure that your auctioneer has a lot of experience in whatever you're trying to sell so that the buyers are there, right? Because ultimately what you want to create if you're going through a liquidation especially is enough engagement that you're finding the value of those assets.
And how do you structure professional compensation to align with incentives? Eric made a great comment about you got to really analyze and determine whether those professionals are going to add value to the whole process. What is some things in representing receivers that you look at when determining how to align the incentives and compensation structures to maximize that asset recovery?
Well, usually it's a percentage of sale. I mean, that's typically, it could be a retainer, could be percentage sale plus expense reimbursement. Sometimes you have ongoing businesses, you would add a kicker at the top, if they hit certain milestones, success fees, those types of percentages that align the sales price with the fees. It just as you said. So typically you can figure that out right away, how you're going to be able to maximize value, and you try to align any type of structure with that. But generally speaking, it's some type of expense reimbursement plus a percentage of sale with some type of kickers is usually, for a larger entity. And it could, for smaller things like just liquidating stuff at auction, it's just the percentage of sale. Sometimes there's buyer premiums, that are paid by the buyer. I mean, it's kind of like, it's kind of like, customs duties, I mean, it's like, who really pays them? I mean, everyone figures it in the price, but they call it, the buyer's going to pay it. So there's all kinds of ways to structure it, but usually it's a percentage of the sales.
I agree. And Frank, now that we've got these professionals underneath our umbrella, our wing, what are some oversight measures and good practices that receivers do to manage these professionals?
Yeah, I mean, the goal is to really not manage them as much as you can. The less, the better, and a lot of it will start with who you hire. If you're hiring the right folks, people with lots of good experience and background and history, you don't want to manage them as much. The certain management, I would say, it happens from the beginning, which is getting their fee schedule, their estimate of completion. Hopefully they stay within budget, and getting updates from them. So if something is not working out well, you at least know sooner than later. But people like, for example, like Eric, who's on this panel. I mean, he's one of the best around, and so I can't
I
see,
wasn't sure which way you were going to go with that one, Frank.
he's one of the best around. So I can't see any really oversight of somebody like Eric, because he's been doing this forever and he's really good at what he does. So the goal is to not manage as much. Obviously, if you get the right folks in place right away.
Yeah, excellent. So, Alan, you touched a little bit earlier on this webinar about ordinary course for non-ordinary course type sales. Can you go in a little bit more specifics as far as the difference between those two options?
Well, ordinary, as we touched about before, really, if you're operating the business and if the business is shut down, it's my opinion, there's no ordinary course of business sale. So you're going to get approval for everything you do. If it's an operating business, and you're able to do like a going out of business sale, not a going out of business sale, excuse me, just a just regular routine operations, then you just continue to buy and sell, whatever product you're selling until you can find a buyer to buy it, as an operating business outside the ordinary course. So generally, if it's operating, that's, you try to continue it and operate in the ordinary course of business, selling goods.
Eric, anything on top of that from a receiver type standpoint?
I mean, I think the one thing Alan was clear on that, but sometimes it's not clear whether your best course of action is liquidation or to keep operating. And so that's where it becomes a little more difficult. And so from the receiver's perspective, general rule of thumb should always be, you represent the judge, go ask him to give you direction. Go ask him to tell you, or her to tell you, here's what I'm seeing, Your Honor, here's what I would recommend, but put it on the record, have them tell you this is what we want you to do, because that's protecting yourself first. Because if you don't protect yourself, then you're opening yourself up to liability. And this is one area where you can have a liability as a receiver. If you start selling assets that you didn't really have the right to sell without some order from the court, then you could get in trouble. And so especially where there's cases where there's question in there, just go get approval, right? I mean, it's going to take a little time. You may not get it done tomorrow. Alan brought up the, selling the shirt, okay, you're going to go sell the shirt. That's fine. But if you decide you're going to go sell the rack in the store, which maybe you don't need anymore, you may still want to go get an approval, because that could be deemed as non-ordinary course of business. And so I think if all else fails, ask for guidance.
I agree. Frank, In preservation of operations pending a sale, when continuing operations, let's say pending asset sale, what are the critical operational aspects a receiver must manage carefully while we're in the process of conducting a sale?
Yeah, another great question, Matt. So, we back to my examples of what we have going on. We have a 14 building complex under receivership. There are apartments, over 510 apartments. And during the pending sale process, it was during the winter here in Michigan. It was cold. It was one of the coldest months um, in January and December. And the critical part is, having, because it's an old facility, we had to change the boilers. Our boilers weren't working. Our heat wasn't operational in certain buildings and areas. So we had to kind of do all that, manage all that, because what we did happen to us is one small pipe bursted. Luckily, it bursted with no really effect. But as soon as that happened, we immediately took action and started checking all the boilers and fix the heats, the heating system in each building. So we had to do that right away. So I mean, stuff like that, especially if you, in a critical weather scenario like we were in, everything was freezing up, and we had to immediately start the process of making sure nothing could go wrong further after this pipe bursted. Another one is like elevators. These elevators stopped working. We had to get the elevator going, and the elevator parts, are hard to find. So we had to call all sorts of people. Finally, found a particular part that was needed to fix the elevators. So things like that. I see like that, especially in the winter where things could go wrong. A receiver needs to be careful of taking care of things.
Agreed. Eric, how can a receiver best manage cash flow challenges and working capital needs while marketing and negotiating a sale?
So I think when you're marketing and negotiating the sale, it can be challenging, right? Because you've been brought into a receivership because it wasn't flush with cash. So, you are going to have some tough conversations with vendors at times that are, maybe necessary even to the sales process. You're going to have to deal with, hopefully your state has a stay order, so you're not dealing with lawsuits flying in across the board in different areas, but it can be very challenging to deal with it. I think what we've found is sometimes you just have to get creative and think a little bit outside of the box. We had the first cannabis receivership in Missouri, and we agreed to the sale order. Judge approved it, and at the time it needed it still would need approval from DHSS, which is the Department of Health and Senior Services in Missouri, which oversees cannabis. And they were running an 18-month period of approval for transfer. So waiting 18 months to cash flow to start paying everything could be very difficult, especially if you're the receiver and you're still having to perform duties and make sure insurance is paid up and anything else. What we did is we found that the state would approve a subcontractor agreement with the purchaser within 1 day. And so we filed to let them start operations the next day as the contractor to us. Now, there's got to be a lot of clarity in there because they're creating taxable events now that you weren't creating before. They're creating new liabilities that they weren't creating, that weren't there before for you. But if cash flow is the most necessary aspect based on timing, you are going to have to get creative. And again, I go back to, and you're going to go in front of the judge and make sure that they're okay with it too. Because if they're not okay with it, you still shouldn't do it, even if it's what you believe is the right path forward. The other thing I will throw in here, because I say this all the time, I know how to run a business. I know how to wind down a business. I am not an attorney. I don't play one on TV. I did not stay at a Holiday Inn Express last night. I need good counsel to represent me so that we are utilizing the law to the greatest benefit of the receivership. And so that's where you need someone like Alan or someone like Frank on your team to make sure that when I say, well, we could bring them in as a subcontractor and let them start creating revenues, and they say, well, no one's ever done that before in a receivership because this is the first cannabis receivership in Missouri, we can sit down at the table and figure out how we make that work
Right.
within the guidelines of the courts.
Yeah, I couldn't agree that having counsel as a receiver is, to me, one of the it's almost number one to the point, because you need to have that legal guidance, and there's always creativity and ways to get things going and get things through. But obviously you want to make sure you're doing it within the guidelines of the law. Speaking of various legal and motion practices, Alan, as far as our last topic, can you outline key elements that should be included in motions seeking approval of asset sales, and also go into, how receivers and receivers counsel approaches court hearings related to asset sales and surely timely and favorable outcomes?
Yeah, so I'll give you from an example. This is a federal receivership case, but we were selling hotels all across the United States, 12 of them from Illinois to Florida to New Jersey. And the first thing you have to do is figure out, okay, in my motion, who am I going to notice? So you got to get your UCC, your judgment lien searches, your tax lien searches, your lien searches on the properties, and you got to make sure they get notice of any motion. So you need to know who you're marketing this to. You want to give it notice to creditors. You also want to give notice to interested parties. And then you have to identify the assets that you're going to sell. You want to make that clear for the judge what you're selling. You want to explain the marketing process you've already participated in. For example, that in that case, we had a broker where we specialize in selling hotels, and they would go meet people all over the country showing the properties. And we also intended to do a final auction online. So we wanted to explain the entire process of what we've done to date, how many interested parties there are, and what we intended to do, so the judge knows exactly what the process is. And then if you have a stalking horse bidder, some of them we did, you want to identify who the stalking horse bidder, what their price is, any bid protections for them, breakup fees, get that all out there. And then lay it out. One of the most important thing is establishing the bidding procedures. I typically like to attach my proposed bidding procedures in a separate page as an exhibit so that everyone understands what they are. And they basically give the receiver authority to do almost anything that they want, frankly. Which since it's been attached, you can say, hey, the judge approved this, and I can, do what I need to do to sell this. You also want to give the judge the authority for what you're seeking to do, because that's critical. In some states, that may be more difficult, and so you may have to do more explaining. And then I always attach the proposed order so people can explain that. And in order, I know we're running out of time, but in order to make it successful, it goes without saying, be prepared for the unexpected, know what the issues are, know what the judge is concerned about.
No, I think that's excellent.
Sorry, I lost you. Are you still there?
Yeah, go ahead.
And then be prepared with declarations and support, or affidavits to support the sale. So the judge has them, they have the evidence they need. And if you know it's going to be contested, you bring your witnesses with you so that you can put them on and either provide direct testimony or let them be cross-examined. So I know we had to do that quick because we're running out of time, but that's how I lay it out. You always got to be prepared. And if you do that, you should pretty much get the order you're looking for.
Yeah, no, I agree. Well, and I know we're getting cut short for time here, but I just want to take one last comments from Eric and Frank. And, I've had the pleasure of knowing Eric and Frank and Alan as well. And, all three of them are individuals who I trust very much, not only on a professional basis, but a personal basis as well. And I always look forward to the opportunity of working with them. So just some final thoughts, Eric, Frank, and Alan, before we sign off here. Eric, start with you.
I will go back to kind of what I said is hire good counsel, make sure that you're well represented. And kind of back to Frank's point of hiring quality people then that are coming in if they're working with you as a part of the receivership, and then talk to your judge, make sure that they are informed of what's going on and why you're doing things, and get the approvals necessary. And if you can keep those two things going, you're going to at least be setting yourself up for the best possible outcome in a bad scenario.
Next, Frank.
Yeah, I fully agree with both what Eric just said and Alan earlier on the notices and the bid instructions. So yeah, absolutely. A great panel, and thank you, Matt, and thank you everyone for being on the panel.
Alan, any final things to sum up with?
Look, I'll chime in and just say, be prepared for what you need to do. Preparation is the key. Working with a good receiver who knows what they're doing is also critical, because you can't be out there. A lawyer can only do so much. We take instruction, we give advice, and we take instruction, but we don't set the course. So the receiver is the key. And you, as a lawyer, you do your best to help them achieve the objectives that they set. And the key to doing that is knowing, being experienced yourself, knowing what they want, knowing what the judge wants, and being prepared.
Well, I'd like to thank Eric, Frank, and Alan for their time. This was an excellent panel with truly just incredible professionals and people, like I said, that I trust very much, not on a professional basis, but a personal basis, and people I would go to hire and to work with when it comes to any type of receivership situation. I also want to thank Daily DAC and Financial Poise, Michael, Julia, Priscilla, Jonathan, the entire team at Daily DAC and Financial Poise for co-sponsoring this, as well as the National Law Review. And of course, to our sponsor, Max Asset. Matthew Brash here. I want to thank you again for listening and participating. We look forward to hearing any follow-up questions. And again, we have another webinar series number 4, or episode number 4 of our series of state court receiverships and how to conclude a receivership. Thank you, everybody, for your time, and we'll talk to you soon. Stay well.
Thank you.
Take care.
Thank
Bye-bye.
you.